Listen carefully, because the rules of engagement for dual citizens in the United States are about to undergo a seismic shift that could threaten your ability to hold two passports, work in sensitive industries, travel freely, or even maintain your U.S. citizenship. Starting in February 2026, the era of don't ask, don't tell regarding multiple nationalities is ending, replaced by a strict new regime of mandatory registration, enhanced scrutiny, aggressive tax enforcement, and zero-tolerance policy compliance. If you hold citizenship in another country, whether by birth, marriage, descent, or naturalization, you are now in the crosshairs of a government determined to track your allegiances, your assets, and your movements like never before. This is not fear-mongering. This is a detailed forensic analysis of policy changes that are already written, funded, and waiting to be implemented by the Department of Homeland Security and the State Department. Welcome back to U.S. Immigration Insight, the channel that refuses to let you be blindsided by policy changes that disrupt your life. Today, we are dissecting the massive overhaul of dual citizenship laws, exposing the hidden traps in the new registration system, and giving you the strategic roadmap to protect your status before the enforcement hammer drops. This is not just an update, it is a wake-up call for millions of Americans who thought their second passport was just a travel convenience or a sentimental link to their heritage, unaware that it is about to become a legal liability. To fully understand the magnitude of this change, we must first look at the historical context and why the tide is turning now. For decades, the U.S. government has tolerated dual citizenship with a policy of benign neglect. While the oath of allegiance technically requires renouncing foreign allegiances, in practice, you could keep your old passport, renew it, and use it without the State Department batting an eye. The Supreme Court effectively ruled in Afroyim versus Rusk that you cannot lose your citizenship unless you intend to give it up. But the government has found a workaround. Instead of stripping citizenship directly, they are making it administratively burdensome, financially perilous, and legally risky to maintain it. The driving force behind the February 2026 changes is a new national security doctrine that views dual allegiance as a potential vulnerability, especially in an era of heightened geopolitical competition with nations like China and Russia. The government wants to know exactly who you are, where your loyalties lie, and what foreign entanglements, be they financial, political, or military, might influence your actions. This shift is codified in the new dual citizenship registration requirement, a mandatory digital census of every American with foreign ties that will create a permanent database of split allegiances. Let's break down the mechanics of this new registry, because the devil is in the details. Starting February 1, 2026, a secure portal will open on the DHS website. Every U.S. citizen who holds another nationality must log in and declare it. This is not optional. You will need to provide your foreign passport details, the method by which you acquired that citizenship, birth, descent, or naturalization, and a history of your usage of that passport for travel over the last 10 years. The deadline is August 1, 2026. If you miss this window, the consequences are severe. You are not just risking a civil fine, which can range up to $5,000. You are risking the suspension of your U.S. passport privileges. Imagine trying to renew your U.S. passport for a business trip, only to be told your application is on hold, pending a dual citizenship compliance review. Furthermore, failing to register creates a permanent red flag on your file that could trigger audits and investigations for years to come. For naturalized citizens, this is particularly dangerous because failure to disclose material facts can technically be grounds for denaturalization. If you hide your second passport now, and it is discovered later during a background check or border crossing, perhaps when you try to sponsor a relative, the government could argue you obtained your status through concealment or lack of good moral character. The impact on cleared professionals is catastrophic and requires immediate attention. If you work in defense, aerospace, energy, cybersecurity, or any field requiring a security clearance, your second passport is now a massive liability. The new adjudicative guidelines explicitly state that maintaining an active foreign passport, using it to enter a country, voting in a foreign election, or owning property abroad will be viewed as a preference for a foreign country over the United States. We are already seeing clearance revocations based on this new standard. You may be forced to make a heart-wrenching choice. Surrender your foreign passport physically to your security officer, sometimes even having it shredded in front of you, or lose your career. This is not just about loyalty, it is about economic survival for thousands of dual citizens who built careers in the defense industrial base. The concept of mitigation is becoming narrower. Simply saying, "I'm willing to renounce," is no longer enough. You may have to actually do it. This affects engineers at Boeing, analysts at the NSA, and contractors across the federal government who have served loyally for years but happen to inherit a passport from Ireland or Israel. Financial surveillance is also ramping up, creating a pincer movement between DHS and the IRS. The Treasury Department is linking the new Citizenship Registry with FATCA, Foreign Account Tax Compliance Act, and FBAR, Foreign Bank and Financial Accounts Data. This means if you register as a citizen of France but have never reported a French bank account, the system will automatically flag you for an audit. The penalties for willful non-compliance with FBAR are confiscatory, up to 50% of the account value per year. Many dual citizens, especially accidental Americans born abroad who have never lived in the U.S., have been non-compliant out of ignorance. This new registry removes the defense of "I didn't know," because the registration process itself will include explicit warnings about tax obligations. You are walking into a trap if your tax affairs are not in perfect order before you register. This is why we advise speaking to a tax professional before you even log into the DHS portal. The days of flying under the radar with a vacation home account or an inheritance in your home country are over. The data sharing between countries is automated, and the U.S. government is closing the loop. Travel is about to get much more complicated, turning routine trips into interrogations. CBP officers at airports will have access to the dual citizenship registry on their screens. If you enter the U.S. on your American passport, but your travel history shows gaps where you obviously used a foreign passport to enter other countries, like Iran, China, or Russia, you can expect aggressive questioning in secondary inspection. Which country is your real home? Why did you vote in that election? Did you perform military service there? These are not casual questions. They are legal interrogations designed to test your allegiance and intent. If you served in a foreign military, even if it was mandatory conscription, you must be prepared to prove that you did not intend to relinquish your U.S. citizenship. The burden of proof is shifting to you. If you hold a high-ranking position in a foreign government, the risk is even higher. The State Department may view this as incompatible with U.S. citizenship. We have seen cases where dual citizens were grilled for hours about their political opinions and affiliations in their other country, with officers looking for any reason to flag them as a security risk. We must also discuss the impact on families. The new rules require parents to register the dual citizenship of their minor children. This affects millions of children born in the U.S. to immigrant parents who acquire citizenship by descent. Parents must now navigate this bureaucracy for their kids, potentially exposing the children to future tax liabilities they didn't ask for. Furthermore, if you are sponsoring a family member for a green card, your dual citizenship status will be scrutinized. Immigration officers will look at whether you are truly domiciled in the United States or if you are merely a paper citizen living abroad. If they decide your primary residence is in your other country of citizenship, they can deny your petition to bring your spouse or parents to the U.S., arguing you have no intent to reestablish domicile. This could tear families apart. Imagine petitioning for your wife, waiting years for approval, only to be told at the consulate interview that your petition is invalid because you really live in Italy, not New York. Another critical aspect is the intersection with social media vetting. The registration portal may ask for your social media handles, allowing the government to scrutinize your online behavior for signs of foreign allegiance. Posts expressing strong support for a foreign government or military could be used as evidence against you in security clearance reviews or border crossings. This creates a chilling effect on free speech for dual citizens, who may feel they have to sanitize their online presence to prove their loyalty. It is a subtle but powerful form of control that extends the government's reach into your digital life. Let's also talk about the specific risks for naturalized citizens. Unlike birthright citizens, naturalized citizens face a slightly higher risk of denaturalization if fraud is discovered. If you register your dual citizenship and reveal that you held a foreign passport during a period when you claimed on your N-400 application that you had no foreign allegiances, you could be opening a Pandora's box. The government could revisit your entire naturalization file looking for inconsistencies. Did you travel on your foreign passport when you claimed to be continuously present in the U.S.? Did you renew your foreign passport immediately after swearing the oath? These actions could be interpreted as evidence that you took the oath of allegiance with mental reservation, a potential ground for revocation. So, what is your battle plan? How do you survive this new regime? First, audit yourself. Before the portal opens in February, gather every document related to your second citizenship. Know exactly when you acquired it and how. Check the expiration dates on your foreign passports. Create a timeline of your travel and passport usage. Second, get your taxes in order immediately. If you have unreported foreign accounts, speak to a tax attorney about the streamlined filing compliance procedures before you register. Do not give the IRS a roadmap to audit you without a defense strategy. The quiet disclosure era is over. You need to be proactive. Third, if you are in a sensitive job, have a proactive conversation with your security officer. Ask about the new guidelines and be prepared to mitigate the risk. Document your willingness to renounce the foreign citizenship if absolutely necessary, but do not surrender the passport until you have a written guarantee that it will save your clearance. Fourth, clean up your travel habits. Stop using your foreign passport to enter countries where a U.S. passport would work unless absolutely necessary. For example, if the country requires citizens to enter on their own passport. Minimize the footprint of your foreign allegiance. If you vote in foreign elections, understand that this is a public act of allegiance that will be recorded. Consider whether the symbolic value of voting is worth the scrutiny it will bring. Fifth, stay informed about the specific rules for your other country. Some countries may strip you of citizenship if you register with the U.S. as a dual citizen. Understand the laws of both nations to avoid becoming inadvertently stateless or losing property rights in your country of origin. Knowledge of both legal systems is essential to navigate the space between them. Sixth, consider the strategic use of renunciation. For some, especially accidental Americans with no ties to the U.S. but heavy tax burdens, renouncing U.S. citizenship might be the best option. However, this is a drastic step with its own exit tax and travel consequences. For others, renouncing the foreign citizenship might be necessary to protect a U.S. career. These are life-altering decisions that should not be made lightly or without legal counsel. The new rules force you to choose a lane in a way that hasn't been required before. Finally, do not panic, but do not be complacent. Dual citizenship is still legal, and for most people, it remains a valuable asset, offering options for retirement, business, and cultural connection. But the days of treating it as a free lunch are over. It now comes with a heavy compliance burden that requires active management. At U.S. Immigration Insight, we will be releasing step-by-step guides on how to navigate the registration portal and legal analysis of the exceptions as they are published. We are building a library of resources to help you through this transition. We are your partners in navigating this new landscape. If this deep dive analysis helped you understand the risks, please like, share, and subscribe. Your support allows us to keep digging for the truth and holding the system accountable. Stay compliant, stay informed, and protect your status. Thank you for watching U.S. Immigration Insight.